To understand what brought Dick Anthony Heller to the Supreme Court of the United States, you have to start with the city he lived in. In 2001, the District of Columbia codified one of the most restrictive firearms regimes in the country. Not a ban on a particular kind of weapon, a near-total ban on the most common one. Under the D.C. Code, the city would not issue you a registration certificate for a handgun, and without that certificate, simply possessing the weapon was a crime. You could not legally carry a pistol in public without a license, and the city did not, as a practical matter, issue those licenses. Even a long gun, owned lawfully, had to sit inside your home unloaded and disassembled, or bound at the trigger by a lock. The statute did not draw a line between the dangerous and the responsible. It did not separate the sober from the violent, the police officer from the felon. Inside a private home in the nation's capital, the law's answer to the question of whether you could keep a loaded handgun to defend yourself was simply no. Which brings us to Dick Anthony Heller. The opinion the Supreme Court would eventually issue introduces him in a single sentence, almost in passing. The justice writing for the court put it this way. Respondent Dick Heller is a D.C. Special Police Officer. By day, that meant Heller stood post at the Federal Judicial Center, the federal court's administrative office, blocks from the Capitol. The district trusted him to walk into that building every morning with a loaded sidearm on his hip. The district gave him the gun. The district authorized him to use it, if it came to it, in defense of the federal judiciary. In 2003, Heller decided he would also like to keep a handgun at his home, not the duty weapon. A handgun of his own in his own apartment, for the reason most people who keep one keep one. He filled out the district's paperwork. The district refused. The man the district trusted to protect federal judges was, in his own living room, forbidden by that same district from owning the kind of weapon he carried at work. So he sued. The case moved the way constitutional cases tend to move, slowly and with detours. In 2004, the United States District Court for the District of Columbia dismissed Heller's complaint. The lower court read the Second Amendment the way most federal courts had read it for decades, as a guarantee tied to militia service, not as a personal right an ordinary citizen could invoke to strike down a city's gun law. 3 years later, in 2007, the D.C. Circuit Court of Appeals reversed. The panel held that the Second Amendment did protect an individual right, and that the district's handgun ban and its trigger lock rule could not survive that reading. For the first time in modern American history, a federal appellate court had struck down a major gun law on Second Amendment grounds. The District of Columbia asked the Supreme Court to take the case. And the court, in the dry shorthand, the United States reports uses for what would become the most consequential decision of its term, said yes. The order simply records, quote, "We granted certiorari." For the first time since the Second Amendment was ratified in 1791, the Supreme Court of the United States was going to sit down and decide, on the merits, what those 27 words meant. 217 years of constitutional silence Second were
Amendment
about
is
to 27 words long. The Supreme Court had spent more than 2 centuries declining to say, in full, what those 27 words protected. Now, in the spring of 2008, a 5-justice majority sat down to do exactly that. Here is the sentence in full. A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. 1 sentence, 2 commas, and 2 ideas pressed up against each other so tightly that for 200 years, readers had been arguing about which one controlled. Justice Scalia's first move, writing for the majority, is structural. He cuts the sentence in half. The opening half about a well-regulated militia he calls the prefatory clause. The closing half about the right of the people to keep and bear arms he calls the operative clause. Then he announces a rule of grammar that will do most of the work in this opinion. A prefatory clause, he says, can announce a purpose. It cannot limit a right. Think about that for a moment. 2 centuries of argument over whether the militia language narrows the right, and the majority's answer is essentially this. The militia clause tells you why the right is protected. It does not tell you who gets to exercise it. The operative clause does that, and the operative clause says the people. From there, Scalia walks the reader slowly through every other place the Constitution uses the phrase the people. The First Amendment's right of the people to peaceably assemble. The Fourth Amendment's right of the people to be secure in their persons. In every other context, he argues, that phrase refers to individuals, not to a state institution. He closes the section with a sentence that the rest of the opinion will lean on. We start, therefore, with a strong presumption that the Second Amendment right is exercised individually and belongs to all Americans. A strong presumption, exercised individually, belongs to all Americans. That single sentence is the doctrinal hinge of the entire case. Once you accept it, the rest of the opinion is essentially a long defense of why the prefatory clause does not pull that presumption back down to a militia-bounded right. But a right to do what exactly? The text says to keep and bear arms, and so the majority turns next to the word arms. This is where the opinion begins to bite. The District of Columbia, defending its ban, had argued that the Second Amendment, if it protects anything, protects only the weapons in common use in 1791. Muskets, flintlocks, things you load down the barrel. Modern handguns, the argument went, were simply not what the framers had in mind. Scalia takes that argument and dispatches it in 2 sentences, and in the process, he uses a word you almost never see in a published Supreme Court opinion. Some have made the argument, bordering on the frivolous, that only those arms in existence in the 18th century are protected by the Second Amendment. We do not interpret constitutional rights that way. Bordering on the frivolous. That is not the temperate language of judicial restraint. That is a justice saying on the record that an argument made in good faith by a city government, joined by amici, briefed in full, is not even worth taking seriously. He compares it in the surrounding sentences to the suggestion that the First Amendment does not reach the Internet because the printing press of 1791 did not produce websites. And then he moves on. Which brings the opinion to the hardest piece of text in the entire amendment. The verb, to keep and bear arms. The district and Justice Stevens in dissent had pressed an elegant reading. To keep and bear arms, they argued, was a single military idiom, not 2 separate verbs, one unified phrase meaning, in the language of the founding era, to serve as a soldier. Under that reading, the right belongs only to those bearing arms in militia service. Scalia's response is in places almost playful. He goes through founding-era dictionaries. He goes through state constitutional analogs. He concedes that bear arms in some military contexts did carry that idiomatic weight. But to read the phrase as a single unit, he says, you have to do violence to the word that comes before it. You have to pretend that keep was just along for the ride. And then he reaches for an analogy that has, in the 18 years since, been quoted more often than almost anything else he wrote. It would be rather like saying he filled and kicked the bucket to mean he filled the bucket and died. Grotesque. Grotesque, one word, a complete sentence. Sitting on the page of a United States Supreme Court opinion directed at a reading of the Constitution offered, in good faith, by 4 colleagues sitting at the same bench. It is the most quoted rhetorical beat of the entire case, and it tells you something about how the majority is operating here. They are not just announcing a holding. They are dismantling in public a reading they consider so strained that the only honest response, in the justice's view, is mockery. Whether you find that bracing or unbecoming probably depends on what you already thought about the Second Amendment when you sat down why Justice Scalia thought the text already answered the question. You have to follow him backward, across an ocean, across more than a century. The majority opinion grounds itself in part in English history, and the story it tells goes something like this. In the late 1600s, 2 Stuart kings, Charles II and James II, used hand-picked militias to disarm their Protestant enemies. By the time Parliament forced James off the throne in 1688, the right to keep arms for self-defense had become, in the majority's reading of that history, one of the wrongs that needed correcting. The English Bill of Rights, enacted the following year, included a guarantee that Protestants, and I am quoting the language directly, may have arms for their defense. Scalia treats that line as the direct ancestor of the Second Amendment. The right to be armed, in his telling, was already, in 17th century England, a right of individuals against a government that might one day try to take it away. Now, a careful note here. This is the majority's reading of the historical record. Justice Stevens and Justice Breyer in their dissents read the same English history differently. They see a guarantee tied to militia service, not to private self-defense in the home. The history, in other words, is not as quiet as Scalia's prose makes it sound. From England, the opinion moves to the founding. And here Scalia describes the militia not as a select unit, not as a uniformed force, but as, quote, all males physically capable of acting in concert for the common defense. He is borrowing that phrase from an earlier Supreme Court decision, United States versus Miller, decided in 1939. The militia in this reading is not the army. It is the people themselves, expected to show up with their own weapons when the moment demanded it. And then the opinion does something worth pausing on. It cites the first Federal Militia Act, passed in 1792. That statute, the opinion notes, required, quote, only whites enroll. Free, able-bodied, white male citizens between the ages of 18 and 45. The founding-era militia, in other words, was not all the people. It was a subset of the people, defined by race and sex and age. The opinion cites this without dwelling on it. We should not skip past it. The historical record the majority leans on is also a record of who, at the founding, was kept outside the door. By the time Scalia has finished walking through the English background and the American practice, he is ready to deliver two things, almost back to back. A final rhetorical jab at the dissent, and the holding of the case. The jab, tucked into a footnote, takes the dissent's reading of the Second Amendment and disposes of it with a literary reference. Scalia writes, quote, the right to carry arms in the militia for the purpose of killing game is worthy of the Mad Hatter. It is a strange line to find in a Supreme Court opinion. Lewis Carroll dragged into a constitutional decision to make the dissent sound like nonsense out of Wonderland. It tells you something about the temperature of the disagreement on the court that summer. And then, after more than 50 pages of text and history, comes the conclusion that becomes the rule of the case. Scalia writes, there seems to us no doubt, on the basis of both text and history, that the Second Amendment conferred an individual right to keep and bear arms. 27 words in the Constitution, 217 years of judicial silence, and now this sentence. But there were 4 justices who looked at the same text and the same history and arrived somewhere very different. Justice John Paul Stevens, writing for the dissent, read the prefatory clause about a well-regulated militia not as a mere announcement of purpose, but as a limit on the right itself. In his telling, the Second Amendment protected the right of citizens to bear arms in the service of the militia, and no more than that. Whatever right to private self-defense exists in this country, in Stevens's view, comes from somewhere else, not from those 27 words. Justice Stephen Breyer wrote separately. His objection was different. Even if you grant the individual right, Breyer argued, the majority leaves judges with no workable way to weigh a gun law against it. No standard, no test, only history. Scalia's opinion takes note of Breyer's framing and dismisses it. The majority refers to, quote, Justice Breyer's assertion that individual self-defense is merely a subsidiary interest